welcome to Short Circuit. Yes, we are doing a live recording today in front of an audience at IJ's Partners Retreat in sunny Southern California. This is a very special episode that I've been very excited about. We have a couple familiar voices that you listeners are about to hear who have been on Short Circuit before, and then we have a first-timer. So joining me are Paul Avalar, who is the managing attorney of our Arizona office, and Patrick Jacquemot, who is one of the leaders of our project on immunity and accountability. Welcome, gentlemen.
Hey, everybody.
Hello, everyone. Thanks for having us back.
And also, we have a special guest who is a bit of an inspiration for how we run the podcast here, as a matter of fact. So we used to, in the old days, have the podcast run by John Ross, who now runs our Bound by Oath podcast, and he did a wonderful job for many years. During the pandemic, we kind of switched things around, and we were all stuck at home, and it was hard to get good advice, and suddenly I was running a podcast, hosting a show. I had never hosted a show before. I had never really hosted much of anything before, not even a party. And so I thought, well, how do you do this thing? Now, of course, my colleagues gave me some great advice, but I had been listening to podcasts for a little while. And one of those podcasts was this great show where they talked about all this crazy stuff that happened to do with the President of the United States, called All the President's Lawyers. And so from some of the cadence they had, transitions between Josh Barrow and his wingman, I got a little bit of tips that I don't think ever translated into how I do the show. I don't think I was good enough for that, but it was a good inspiration for me. And so I'm very happy to have Josh's wingman here today, Ken White. Ken is a longtime criminal defense attorney and First Amendment lawyer here in Southern California. He's at the firm of Brown, White, and Osborne. Most listeners, however, will know him by the moniker Pope Hat. And you can catch him these days on Josh on his new show, Serious Trouble. So Ken, welcome to Short Circuit.
Well, thank you. I do want to say for the record, I think Josh is my wingman, but, you know, I guess that's a matter open to dispute.
Yes. Well, I guess whether or not you prefer the person giving the straight news and asking for what's going on, or whether you like the lawyer who ruins everyone's hope and dreams with the cold reality of the law, you know, is going to depend on your point of view.
Okay, that part I'll own up to.
So before we get started, there is one question I wanted to ask that I'm sure a lot of people would like to know, and that is, how the heck did you get the nickname Pope Hat?
Well, that's about 20 years old, and when I started writing about legal issues, mostly criminal justice and the First Amendment, on the internet and started a blog with friends, I picked that name as a reference to a friend who was a origami expert, and he loved to make things with origami, including little origami miters, Pope hats. And it seemed when he was wearing an origami miter, he was infallible, undefeatable at poker. And so it was a reference to that and to the idea that people who are on the radio or write online tend to think that they are infallible. So it seemed only appropriate.
So we are going to be infallible about our opinions today on the 5th, 6th, and DC circuits. And we're going to start with one of our favorite subjects, always, what the heck's going on in the 5th Circuit. And that is a case Ken is going to do, Missouri versus Biden.
Absolutely. Recently, in the 5th Circuit, informally known to some of us as the, oh my God, I can't believe you wrote that circuit, has just reviewed and significantly changed a lower court decision on a very controversial issue. And that was a lawsuit by the states of Missouri and Louisiana and a handful of internet users against Joe Biden, the Department of Health and Human Services, and a variety of government actors. And this was over the issue of whether or not the government was violating people's First Amendment rights by influencing social media platforms to moderate them or ban them or deplatform them, particularly during COVID. And these plaintiffs claimed that the White House, that the Surgeon General, that a bunch of other government agencies got involved in going to Facebook and Twitter and twisting their arms to get rid of people for saying things like, the lockdowns are bad, or that, Bill Gates is putting microchips in us through vaccines, or whatever, a wide range of things from maybe just a little bit outside the mainstream to really crazy stuff. Much earlier in the year, there was a very lengthy, very vivid opinion from a trial court judge finding that, yes, absolutely, the government's done all this completely unacceptable arm twisting, and it crossed the line into a First Amendment violation. Because, of course, normally when Twitter and Facebook and these companies ban us for things that, we meant in the best way, that's not a First Amendment violation because they're private actors. But there is this doctrine that says at some point when the government gets involved with encouraging a private party to get involved with your rights, that can be state action. That can be a violation of your First Amendment rights. The trial court decision was pretty controversial, possibly because it was written as is kind of the fashion now a lot of the time, in a very overtly political kind of, some would say, screed type of fashion.
Judges being political?
Yeah, I know it's hard to believe. It landed in a way that I think was very partisan, with people either saying, "Oh, absolutely, that's right. That's what this administration is like. They're all evil," or saying, "Clearly, this is a Russian /anti-vax plot, and it's all nonsense." So, what I like about this decision on September 8th from the Fifth Circuit is it's a really thorough, professional evaluation of what the actual law is and the evidence is. And I think it really cleaned up the lower court decision to a place where people are going to be a lot more willing to actually examine the First Amendment issues. So what they did was they went through the evidence and put it, because they were being a little less screedy, in a significantly more convincing way, that yes, there actually was a substantial amount of actual arm twisting and veiled and not veiled threats from government actors to social media platforms that caused them to moderate things that they were not otherwise moderating during COVID, relating to election disinformation that the government believed originated with the Russians, and so forth. And then the circuit did a quite good, quite clear job in this lengthy opinion of explaining where that line is, because it's not an easy line, between the government's right to jawbone, as the term is, to advocate for things, to encourage the private sector, versus going into a realm where they actually coerce. So it talked about these two ways the government can go too far. One is substantial encouragement, which means a lot more than it sounds. It really means being so involved that they're making the decision. Or coercion. And of course, because it's a circuit and multifactorial tests are circuit judges' crack, they gave us a nice, clear 4-factor test. It's kind of really a tribute to Anthony Kennedy in a way. And so that we could all, in the future, have a better way of telling what's acceptable government involvement and what isn't. So the circuit opinion actually turned me around a little bit. I was skeptical of the trial court opinion because it was so overtly screedy. I found this much more convincing. I'm fairly convinced they made a good case of actual interference by the government, notwithstanding that I'm probably more sympathetic to the government's viewpoints on these things and the things they were trying to get moderated. And then I think one thing this opinion doesn't talk a lot about is transparency, and that one of the main reasons this comes off as so offensive, as so scary, is it's going on behind the scenes. And so that kind of plays into a lot of current movements towards maybe social media companies and other companies, when they're being contacted by the government, should keep some sort of log, a public log of the government came to us about this, and that would be a good thing. The other note about this case, of course, is that you came to me in prep for this. We had some excitement this week, or what passes for excitement for people who closely follow circuit court decisions, where the circuit first granted rehearing, and which would mean the opinion would be wiped out, and then reversed that and said, no, we don't, strike that, file a brief about rehearing. And it came out in the paper that a clerk actually said, oh, sorry, that was our mistake. There was a certain amount of speculation and conspiracy theory about what was actually going on, but it was purely a clerk making a mistake. And as we all know, when a clerk makes a mistake, at least those of us who are married know, the thing that you do is you apologize to the clerk for your role in bringing about the mistake. So now I suspect it won't get reheard. I'm not sure it's ripe for Supreme Court review simply because it's very fact dependent in this case. And I don't think this yet diverts from other circuit views on where the line is.
Yeah, even though it does go the other way from some of those other recent cases on whether there was coercion or not. But you think it's just different facts, and so it lands on the other side of the same standard?
Yeah, because I think they adopt standards that have been used in the Second Circuit and Ninth Circuit, widely seen among themselves as being the most important circuits. So it doesn't really go out in a new way on new law. I don't think Supreme Court right now is so much taking on cases where they're just having a different factual interpretation of historic events.
Well, I sort of ask a meta question here, and I don't mean that in the punny way. The Supreme Court has taken a couple of cases last term and this term dealing with free speech and social media. Last year was the Google and Twitter cases about Section 230 that they kind of wound up ducking. And then this term they've taken two cases involving politicians or lawmakers who blocked people from commenting on their Facebook pages, and remarkably, neither one of these politicians was named Trump. So we've got another two of these cases that are out there. They do seem to finally be taking an interest in free speech and social media. Do you think they're going to stay out of this one simply because facts matter and this is a very facty kind of case?
Well, I would be surprised simply because this comes out as a decision that's very pro-free speech. One thing the Circuit Court did that was important is it cleaned up the extent of the injunction, which is often a Supreme Court bugaboo. The judge had basically enjoined every government official in the entire country from saying anything to social media anywhere. And the circuit came back, no, we're going to narrow that down to no coercion, because that's what's against the Constitution. So we don't have that factor. And actually the plaintiffs themselves like the result. They don't seem to they only want it tweaked just a little bit in their petition for rehearing. So I don't think there's going to be the big impetus to solve a circuit split or correct something that's seen as a First Amendment injustice.
Yeah, my initial reaction was first, wow, this is a 74-page per curiam opinion, and I wonder if that is a record. And just for the listeners who don't know, per curiam opinions tend to be very short. In fact, the case that IJ just got certiorari on, de Villiers versus Texas, is another Fifth Circuit per curiam opinion that's literally a single paragraph long. So we see going from one paragraph to 74 pages. This is an interesting use of the per curiam. But I think the most important thing, and this goes to Ken's point about the cleaning up of the district court opinion kind of probably shifting the way a lot of people feel about the ultimate result of this lawsuit at this stage, is that as the Fifth Circuit's going along in this decision, it repeatedly emphasizes if Twitter or Facebook or other social media, which are private companies, want to censor people however they choose, they can do that. But that's not what the plaintiff's arguing here. And so the crucial fact in this case that everyone always needs to keep in mind when we're talking about social media and censorship is that the legal problem here is that the government was at least allegedly twisting the arms of these companies or strongly encouraging them to act essentially as a cutout for the government to silence critics.
The interesting thing I saw was the play between this and the Elizabeth Warren case from the Ninth Circuit that we actually talked about on Short Circuit a few months ago, where she was basically mad at Amazon, and so was she's just 1 out of 100 senators. She doesn't have executive authority to prosecute under the antitrust laws, but she was sending these messages that were allegedly construed to be blocking some publishers on Amazon. And the Ninth Circuit ruled that was not coercive. But here it seems that I think this is definitely more on the coercion side of the line. But if you put those two together, I think those will be some guideposts going forward. And so if this doesn't go to the court, which I agree, I think that unlikely, these are maybe the two cases to keep an eye on in coming years when it seems like this issue is perhaps going to keep coming up.
Well, here, I mean, the Fifth Circuit basically adopted the Ninth Circuit standard there, their multi-factor test. And I think it was a legitimate take that the coercion here was more substantial than Warren's coercion. It is interesting at how right now the script flips for so many people depending on who or what is being coerced. So the same set of people might have radically different reactions to, say, what Governor DeSantis is doing to Disney versus what the Biden White House is doing to Twitter, depending on their own political predilections about coercion.
You mean it's not just judges that are political?
That's what I've heard.
One other point on this clerk, I believe the Fifth Circuit that the clerk made a mistake. But it's not like, they put a not in the order instead of a did. It was pretty detailed about remanding and granting, and that might have been a funny game of telephone within the office, but I wonder if there was something else going on there.
Well, a lot of this stuff I understand is kind of done with automated systems and drop-down menus and stuff like that, and they can be and let's just say I tried to e-file something in a federal circuit once, and it did not go well.
Yes. God bless our paralegals.
Exactly.
Well, elsewhere in the country, in the Sixth Circuit, we have some other abuse of discretion, but in a little different format. And we're going to be getting into here something we talk about a lot on the show, which is government immunity. But a twist here is instead of qualified immunity, usually involving the police or other government workers, we have judicial immunity, maybe the most powerful immunity of them all. So, Patrick, tell us the story of this judge's courtroom.
Yes, so this is a case from the Sixth Circuit called Orta versus Rep, and Rep is the name of the judge from rural Ohio, Mark Rep, who seemed to be running his court like his own little fiefdom. And what happened in this case was a woman was coming to court to watch a criminal proceeding for the father of her two children. She was sitting quietly in the back waiting as the first case was being heard on a completely unrelated matter. And in a very bizarre fashion, this judge begins heckling her and suggesting that she's under the influence of drugs. Now, what's clear after the fact is that he had no evidence for this whatsoever. She'd been sitting quietly. She was exhibiting no outward signs of having any sort of drug problem. This was just some weird issue that he was latched onto, and we'll get into in just a second perhaps why he was doing this. But as the morning progresses, he keeps making comments about her being on drugs. It's very strange. He ultimately, in the first case, orders the criminal defendant to be drug tested, and he says something along the lines of, I think we're going to have a few drug tests today. What do you think, Miss Orta? Before her boyfriend's case is called, he then instructs the bailiff to take her and have her drug tested. Now, she's just someone who's in a public hearing. She's not before the court. She has no criminal history related to the court. She has no, drug history that the court is aware of. He simply just is saying, you're in my courtroom. I'm going to make this bailiff take you and drug test you. So the bailiff takes her out of the room. They go back. She refuses to take a drug test because why should she? They make her wait and wait and wait. Meanwhile, her boyfriend's case is called, and the judge continues in a very unprofessional demeanor. He's casually swearing on the record. He ultimately says to this man, well, your girlfriend might be going to jail too today, so I hope someone's watching the kids. After lunch, this woman is brought back into this courtroom, and the bailiff tells the judge that she has refused to take the drug test. And so what he does is he holds her in contempt of court and sentences her to 10 days in jail because she wouldn't take a drug test. So she's carted off to jail, at which point she starts to panic and thinks, like, who's going to take care of my children? Okay, I'll take the drug test. She tells an officer at the jail. He says it's too late. So she ends up stuck in jail overnight before the next day, and this is a really remarkable fact, the local prosecutor goes into the judge's chambers and basically says, you can't do this. You need to drop these charges. And this actually isn't in the Sixth Circuit opinion. It's in some of the other ancillary documents from the related cases. But the judge ultimately does agree to drop the charges, but he says she has to get into some drug diversion program. That's ultimately thrown out. The charges against her are thrown out by the Ohio Court of Appeals. And here, the good news of this story is, ultimately, this goes up to the Ohio Supreme Court, which suspends this judge not only from his judgeship, removing him from office, but also suspends him from the practice of law as an attorney for a year. So there is something good that came out of it.
Consequences?
Yes, well, don't worry, we're going to tamp those down. So this woman sues this judge and says, you violated my constitutional rights for obvious reasons. And the judge, of course, claims judicial immunity. And as many of us have heard about qualified immunity, which is created by judges, you might not be surprised to learn that judges have created their own judicial immunity as well, which is much stronger. And this immunity covers judges absolutely for everything they do in a judicial capacity, as long as there is some potential claim for jurisdiction. And so what the Sixth Circuit actually says in this case is, what he did was terrible, sure, but he had the power under Ohio law to hold people in contempt. That's subject matter jurisdiction, and obviously he was a judge on the bench when he did this, so he was acting in a judicial capacity. So that's just too bad. The case is dismissed. But, of course, we're going to do a little bit of throat clearing and say, one, it's not so bad because this judge faced some consequences. And two, of course, as you always do when you're sanctioning something terrible, you say at the end of your opinion, what happened here is terrible and we absolutely do not condone it. Which every time I see that, I have to Google the definition of condone again, which says to permit. It's like, yes, that is in fact what you are doing by allowing this to happen. And the thing that's very interesting here is that the history of judicial immunity is that the Supreme Court created it and they said, we have to do this for the good of the people. It's not to protect the judges. It's to protect the integrity of the system. And there is something to the fact that you don't want every person who loses a lawsuit to be able to turn around and sue the judge. But the problem is that what the court predicated all of this on was it didn't want judges to have to be concerned about personal consequences for things they were doing so that they would be fearless in making their decisions. And so when you have a situation like this, where courts have said, sure, you can't sue a judge for money if they do things like this, but they could be prosecuted for their actions as a judge. They could have consequences at the state bar, as was the case here. There are places where consequences are allowed. And so it doesn't make sense, to me at least, why judicial immunity should apply in a situation where a judge does face consequences, and here did in fact have consequences, because in situations as egregious as that, we do want them to pause before they do these things. And the real problem with this application of immunity, especially through the contempt power, which often looks a lot more like prosecutorial action than judicial action, is there really is no good limiting principle. So, of course, there could be a judge who does something like this, but you could also have a judge say, hey, sir in the back, Kramer, you're very annoying. I'm going to hold you in contempt and sentence you to death, which I will now carry out in the courtroom. And presumably the judge will face some consequences for that, but they won't be in a civil rights lawsuit because they'll have judicial immunity, at least if you actually apply the standards as they've been written.
Well, the carrying out would be executive.
You'd have to have the bailiff do it.
That's right. There you go.
Yeah, that's an interesting question. So was the bailiff sued?
The bailiff was sued. I actually don't know what happened. So this is a case where they had the Rule 54B separation, so they got to appeal the judicial immunity separately. So I'm not sure what's going on with the other claims. Yeah,
it does seem so that this line that this can be under the judicial immunity umbrella seems fantastical. But that this seems to be a trend. Maybe it's just because I've been reading too many of these opinions lately of courts saying, "Oh, this is really bad. What happened? We do not condone it. Tuss. But in this one case, we don't think we can give a compensation to the victim."
Yeah, and obviously we see this happen all the time in our immunity cases. We have a case in the Eighth Circuit called Polreese where this happened, where a police officer held two, underage boys at gunpoint because he was looking for adult suspects. And the circuit ultimately granted qualified immunity and then had like a paragraph at the end that said, we really feel for these boys. What happened to them was terrible and they comported themselves with, dignity and respect. Nevertheless, immunity is granted.
We talked about a judicial immunity case on the show a few months ago, and it was kind of a split decision where the judge was putting these children in jail, basically. And because he literally was not wearing the robe and was outside of the courtroom, that the case could go forward, but a different claim where he did other reprehensible things, but it was, he was sitting on the bench with a robe, seemed to be the difference, even though there wasn't really much of a line other than that.
Yeah, so that case was called Rocket versus Amy, and we actually did an amicus in that case, and IJR Tory Clark argued as amicus before the court in that case. And yeah, so there you had a judge who physically escorted some kids to jail and put them in jail because they didn't like his decision that they had to live with their mom. And then separately from that, he issued a completely illegal order that caused them to be arrested in another state. And so the distinction that the court made there was, well, the robe piece of it was just kind of color. What they were saying was, in taking them physically as the judge and walking them and placing them in a jail cell, that's an executive function. And so it wasn't judicial. That's being a police officer. But if you wildly misinterpret the statutes and illegally cause them to be arrested in another state, well, judges are able to issue orders for pickups and bench warrants and things, and so that's fine.
So is there another line we could have? I mean, do you have an idea for something different we could do here?
Yeah, so I think I certainly think there should at least be an exception for situations where there are otherwise consequences for the judges, because at that point, the justification for the immunity has already evaporated. And we want judges to be concerned that if they do certain things that they might be criminally liable for or be disbarred for, that they could also be liable in damages. And the reason that's important is because that's the only thing that gives Alexandria Orta a remedy for the violation of her rights. And so here it's kind of cold comfort because you have two sides of every coin. Sure, the judge has been held accountable in some sense because he's faced consequences, but Alexandria Orta's rights have been violated and she's never been made whole for what happened.
You wonder if you could come up with some sort of standard where the judge had no plausible or colorable claim of law to do what they did.
Yeah, and so one of the two standards is for how you get around this immunity is if someone's not acting in the judicial capacity, that's one thing, or if they act in the complete absence of jurisdiction. And what the court has taken that to mean isn't that you acted without jurisdiction at all. It really has to be bad. And so it's really never been clear. And in fact, in this decision and in a lot of others, they always cite back to the single example from a case from 1871 where the court said that would be like if a probate judge sentenced someone beyond a criminal maximum. And we say, well, a probate judge has no jurisdiction over criminal matters. It's like, sure, that's great. That should not get immunity. But there has to be something less egregious than that, where you say, oh, and this might be just as simple as in the qualified immunity context, an obviousness exception, where there have to be cases where, every reasonable person would say, no, of course you couldn't do that. Of course you couldn't just say hey, the Sixth Circuit's coming to hear cases in Cincinnati. I'm an Ohio court judge. This opinion offended me, so I'm going to issue a bench warrant for Judge Sutton and have him arrested. And, nobody would think oh, well, that was a judicial act.
Don't be giving listeners any ideas here. So moving to a different subject now, we have an intellectual property case, which we don't get to all that often on Short Circuit. We had an ERISA case a few weeks ago that I got a little flack about, to tell you the truth. I thought it was interesting. But now we're going to turn to a property case, but it has an intellectual property case, but it has all kinds of intersection with due process and how the law even just gets made. So Paul is going to talk about this American Society for Testing and Materials versus Public Resource Org from the DC Circuit.
Right. So you promised infallibility earlier, and I will confess I know absolutely nothing about copyright law. And so I was planning on cruising right past this one while I was reading for cases for this, and then I noticed that there was a whole long list of amicus parties in this case, and I thought, that's usually a pretty good sign that something weird is happening, and weird is fun. So the plaintiffs are private organizations who develop suggested technical standards in their fields for industries or products. Actually, Patrick has run into these guys before in his capacity as a private attorney. So who is ASTM?
Yeah, so in my previous life as a civil attorney, I discovered in a case involving whiteboards that ASTM is this organization that sets all sorts of industrial standards for everything you imagine. And you can see it now. You'll have this experience now where you start noticing it all the time. If you have a dry erase marker, for instance, in really tiny letters, it'll say ASTM and then some numbers. And if you Google this, you'll eventually get back to one of these standards that this case is about, and it'll say, the standard for dry erase markers is that they have to be completely erased through 7 wipes at an average pressure of 14 pounds. And so, like, the reason that these things exist is that a lot of industrial contracting is based on these as sort of accepted standards. And so, if I'm going to order a bunch of dry erase markers from a producer, the contract will say they need to meet the ASTM standards because that's just the industry agreement.
Well, that's not all they're used for, as it turns out. Many of these organizations promulgate these codes, and then, I'm sure not coincidentally at all, the government then adopts the codes as governing law. If you've ever seen, say, the International Building Code, that is a code that is written by a private organization that is then basically adopted by almost every municipality and government entity, local entity in the country, and that sets the standards for how homes or buildings or bridges or whatever gets built. And so, say, not hypothetically, you are suing the state of California over the way it regulates site plans, and you want to find out what does the California Building Code say about site plans, you go and you find out that, in fact, the law is copyrighted. It's actually held in copyright by the private organization. They are, after all, the ones who wrote it. And so you go to the state of California and you say, can I get a copy? And they say, no. Well, that's a real problem. Enter publicresource.org, which is a group that comes in and collects all of these materials and then publishes them on the internet for free for anyone to see. And so all of these private organizations sue publicresource.org for copyright violations. You have our copyrighted work and you're putting them up on the internet for anyone to see without regard to our copyright. And so that's what this case is about. So here, what the D.C. Circuit says is, in this case, it's sort of bounced around a little bit, in this very, very interesting, if you're into copyright law, multifactorial inquiry, what we find is that publicresource.org is actually engaged in fair use. Because they're using, publishing, taking copyrighted materials, but they're putting them on the internet for free for educational purposes. And, that's fair use. They're not doing it commercially. They're not charging people for access to this. And clearly this is an educational purpose about something really important, i.e., the law. If there's this presumption that we all know the law, and that's the reason why we have to follow it. Well, what happens if the law is subject to copyright? If I want to know what my house that I want to build is within compliance, I have to go buy a private code from someone and pay like $300 for it. That doesn't make a lot of sense. And really, so that's the case. Fair use, great. You can go find that stuff now. To me, the more interesting is sort of the background here. And there's this idea in the law called the government edicts doctrine, that no one can own the law. That, say in one of these cases, the judge heard that we were discussing it, and they're like, hey, wait a minute. I wrote that opinion. I have copyright on that. How dare you talk about my case and cite it in your briefs and such without paying me my royalty for my copyright? You just can't do that. Government officials, when they're working in their official capacity and they publish something, that's government edicts. And so the weird questions in these cases are like, what's the effect of that doctrine with copyright for these private organizations? And publicresource.org has actually sort of been doing this for a little while. They were at the U.S. Supreme Court a couple of terms ago, fighting with Georgia over the copyrighted parts of its state code, which didn't make any sense to me because Georgia thought it could copyright parts of its state code. You can't do that, by the way, 9-0. So, but this is becoming, I think, more and more of an issue because, again, lots of these standards are everywhere. There's lots of organizations that promulgate these standards, and they're adopted across a wide variety of fields, everything from, as I said before, building codes to what are the standards for car seats. Like if you want to know what car seats to buy, which ones meet the standards and which ones don't, and those are adopted by, I think, CPSC. you have to go pay for a copy of the code to go find out what it is. And so, who controls stuff that becomes law? And there's lots of other potential ramifications here for property. After all, copyright really is property. How are we going to protect that, but also allow people to get access to it? But anyway, a fun copyright case, if there's such a thing as a fun copyright case, sort of pointing to this larger. And I like it because, to a hammer, every problem looks like a nail. To a constitutional lawyer, every problem looks like due process. And this looks like a due process thing to me.
I can hear all the IP lawyers who listen to the show, who I do know there are some, screaming while driving to work this morning about how that, of course, their field of law is very interesting. And Paul, you just don't appreciate us enough, which might be true. But I see this. Along the same lines, but I think one thing that people involved in the nitty-gritty of these codes, and then who are maybe the city attorney who suggests that they incorporate in the ordinance and how all that business gets made, is they assume that the only people who really will care about what these codes say are like people at engineering firms who already have a copy on the shelf and would have it anyway. And so, you just go refer to your own private library if you want to know the law. Well, I've been in some property rights cases at IJ, and I was looking at the ordinance of the city we were suing. It says, well, this is the code. And I was like, oh, what's that? How do I go find that? Oh, it's $299. I could order that today, or I could go to this obscure library and try to find one. And it actually does have a practical issue to property owners or small-time lawyers or what have you.
I can't imagine that these companies make their money by the numbers of copies of these model things that they sell, do they? Because, maybe a good government way to do it is have the government say, we won't consider your model standards unless you agree to make them available on the internet for free if we adopt them.
I don't know what their business model is. Another option here is, yes, you have a copyright in the thing that you created, and we're going to enact it, we're going to adopt it into law. That must make it publicly available. Well, that sounds like possibly a taking of intellectual property. It's for a public use, so the public can know what the law is. Crazy idea. That's taking. The government would have to pay for that sort of thing. Maybe if the government had to pay for the laws it enacted, we'd have fewer of them. I don't know.
It seems to me there's something here, too, about the fact that these standards organizations, I'm sure, are happy that their standards are put into law for all kinds of reasons. But if you had some standard like this, a group of people put together, and what they make gets put into law, and then that makes it fair use, and they didn't want that, there could be something else there. And it seems like the standard maybe is flexible enough that that wouldn't be. But that is very much not the case with I think all of these standards organizations.
Yeah, I was actually wondering, and talking to Paul briefly before we started, what if you had some malicious legislator who had a bone to pick with J.K. Rowling, and they said, we're now enacting all of the Harry Potter books into the California statutes. And I really don't know what that looks like.
We're putting it in the Federal Reporter.
Yeah, exactly. Or you just attach them to your court decision. The other thing that comes to mind when we're talking about this is, you shouldn't have to pay to get the law. And I'm thinking like, man, I've paid a lot in PACER fees over the years to see what the law is as articulated by the federal courts.
Or lawyers. You're supposed to pay us to get access to the law. What did the other people are? This is the unauthorized practice of law, these industry groups writing codes. Heresy.
Well, of course, having just sat through a bunch of Institute for Justice seminars, I'm suspicious that this is actually a cartel of industry groups passing and offering codes that will help fight off competition.
Oh, you're so cynical.
Oh, yeah.
Well, we're going to have hold the rest of our cynicism for the next episode. But for today, I'd like to thank my three guests for coming on Short Circuit. Very much appreciated each of them, especially our friend here, Ken White. I'd like to thank the audience who was here live with us today and all our listeners. But in the meantime, I hope that all of you get engaged.